Yes, Mr. Simpson.
My lords, Mr. Lundy took you to certain paragraphs of the defence and Knight Frank's defence.
Sorry, you're going to look at the Knight Frank defence?
Yes,
Okay.
my lords, because of the point that the fraud allegation relies on the bid process, and there are very important paragraphs of the Knight Frank defence to which you haven't yet been taken. I'm going to return, as I started, to the pleadings.
But are we not having a bit of a mini trial here?
No, my lord. We are merely, I am going very briefly simply to draw your attention to relevant paragraphs insofar as it is said that the bid process is fraudulent and there's an arguable case here based on Knight Frank's defence. I could simply ask.
But of course, it's not put as fraudulent.
No.
It's put as a transaction which was a sham or was willful, constituted willful misconduct because the proper process wasn't gone through.
Yes, well, look, perhaps I should stick to my original course then in that case.
Okay, we'll do whatever you want.
Which was to look at the pleading, dissect it, say there's nothing in it, and say that the judge was right to find there's no real prospect of success in the willful misconduct case, and insofar as she didn't consider, because of her earlier decision, the gross negligence case, that there's no real prospect there.
You say she was right about that as well, do you?
Yes.
She was right about the sanctions.
My lord, I say she was right about sanctions, but that's an anterior point. At the moment, I'm proceeding on the assumption, without conceding, that your lordships are re-exercising your discretion.
Let's have a look at the whatever it is, the Knight Frank defence, which is important.
I'm grateful, my lord. So that's
so you're interpreting the judgment as the judge saying no real prospect of success.
No, as your lordship will be aware from our skeleton, we did take that position in our skeleton. We took the position in our skeleton that she didn't quite go that far. The language doesn't look as though she goes that far. But on further reflection, we would submit that in the context of her setting herself the test earlier in the judgment of real prospect of success, that language is indicative of her finding that there was no real prospect of success, and she was right on that. Alternatively, if that was not what she found, if your lordships re-exercise the discretion, we say that there was in fact no real prospect of success. I think your lordships referring to a language such as weak and speculative, which doesn't appear to reflect the summary judgment threshold. But if one looks earlier in the judgment, that is the threshold that she sets herself. She mentions real prospect of success. So I'd resile from any concession that she didn't make that assessment. Well, also, I'm in your lordship's hands as to where I go, whether I go to the pleadings or to the Knight Frank.
No, we're in your hands, quite the reverse.
My lord, I'm grateful. So the Knight Frank defence, S1 page, tab 3, page 39. Now, my lords, as your lordships correctly observed earlier, this was not canvassed before the judge. So I deal with it now. It's not dealt with in our skeleton, therefore. And so I deal with it now in reply to my friend's reply to our respondent's notice. So we got to the bids being submitted at paragraph 34.1.4 in the first round. 34.2, a bid schedule is drawn up. It refers to the offers mentioned in the defence. There's a meeting on the 17th of November. They run through the bids with Knight Frank. Galliard hasn't yet confirmed, but they confirm at the meeting. 34.4. And then, my lords, after the first round, 2 further bids are received. The Galliard one's late but confirmed, and there's an amended bid schedule issued. Further offer on behalf of Sun Hotel on the 20th, further revised version of the bid schedule, and third bid, further revised version of the bid schedule. And Knight Frank then, on instruction from the receivers, Knight Frank invite Reichman and AGTT to submit second round bids by 24th of November, 12 noon. And then on closure, there's a meeting of second round bids at which various things are discussed. AGTT had pulled out. Although Reichman had confirmed their first round bid, they might be persuaded to bid higher. And Meadow were likely to submit a bid, they were told. These are the lenders. And for present purposes, it's assumed that they're a connected party. Maybe an issue at trial, but it's assumed they're connected. We're assuming, therefore, that there is some. They're not just a third-party bidder out of the blue. These are related to the lenders. Meadow. Knight Frank recommended, given the likelihood of Meadow bidding, any next step should be kept as transparent as possible. Agreed the debt value would be calculated. Receivers would inform Mr Samady of the second round bids, and negotiations would be open with Reichman on or around 27th of November. After the call, Knight Frank prepare and distribute a bid schedule. The bid schedule set out two bids, which is the Reichman bid and the Meadow bid. And then on the 5th of December, there's a calculation of the value of the outstanding debt and therefore of the Meadow bid, which is for the outstanding debt. Now, this is very important in our submission, my lords. In accordance with those instructions, Knight Frank prepared and issued to the receivers by email a draft recommendation report on the 6th of December, which described in summary the marketing process undertaken by Knight Frank, the level of interest in the property and the subsequent bidding process. The report concluded in relation to the two second round bids in the following terms. We've discussed at length in our various conference calls the merits and risks associated with these two offers. As far as certainty and low transactional risk is concerned, the Meadow offer represents the safest bid. It's also at a higher level and on preferential timescales. We would therefore recommend that you accept the Meadow offer on condition they exchange in accordance with the terms proposed above. On receipt of that report, D3 sent an email to Knight Frank saying the terms of the Meadow bid had changed, such the proposed completion date was now 31st of March, and exchange likely to be within 15 days of the offer, and asking whether Knight Frank recommended the Meadow bid as varied. In response, Knight Frank issued a revised draft recommendation report to the receivers by email, confirming its recommendation to accept the Meadow bid as varied. On the 8th of December, that's the day of exchange, Knight Frank issued a final recommendation report to the receivers, which included a recommendation to accept the Meadow bid as varied in terms materially identical to that set out above at paragraph 36. Now, my lords, no allegation of wrongdoing, impropriety, fraud, willful misconduct has ever been made by CNM against Knight Frank. And on the basis of these emails and these facts, therefore, the receivers acted on the basis of the honest advice of Knight Frank in disposing of the property to Meadow. So insofar as CNM relies on Knight Frank's defence to build a case of whatever it may be called, willful misconduct, collusion, fraud, that is broken by the later paragraphs of that defence, we say. Now, moving back to the pleadings and the amended draft amended particulars of the 6th of May at C11. Now, my lords, I may have used rather too broad a country house analogy, but my submission to your lordships is that the whole edifice of the willful misconduct case is built on the Hartland Agreement and failure, allegedly, bring that to the attention of prospective purchasers, even though Mr Samady didn't send the receivers a copy, didn't tell them the terms of it, didn't tell them Mr Ross was a party to it, even though requested, he did not send them a copy. And he himself did not bring that agreement to the attention of the two purchasers, which is common ground he saw around that time. So it's said that the information was willfully withheld from...
Where are you? 74?
74, my lord, yes, so sorry, yes. I've analysed what information Knight Frank had and how they couldn't have passed on information they didn't have, in particular in relation to the anxiety to sell.
You mean the receivers?
I'm so sorry, the receivers. Yeah. I've analysed that, and the next section says, despite multiple requests from Knight Frank for this information to be made available as requested by potential buyers. Now, this allegation is obviously also infected by the same problem of not having the information and Knight Frank not having the information. And the insuperable problem to start with this clause is that CNM's whole case is based on the proposition that potential buyers knew nothing about the Heartland Agreement or Mr Samady and Mr Ross's eagerness to conclude a deal which was favourable to them, which is the basis of the case that was sold at an undervalue. How then, my lords, could, or just asserting it, potential buyers therefore could not have asked Knight Frank for information about it. And consistent with that, Mr Samady doesn't particularise, or CNM doesn't particularise or rely on any communications evidencing that they did, as the judge noted at the end of paragraph 16 of her judgment. Now, the second fundamental problem with this assertion, that there were multiple requests from Knight Frank for this information to be made available as requested by potential buyers, is that if Knight Frank had made any or all of these unparticularised and unevidenced requests to the receivers for this information on the Heartland Agreement and the Samady Ross willingness to sell, then that would clearly have been at the heart of Knight Frank's defence. We asked that all this information should be provided. But Knight Frank's defence, in fact, was that there was no material reasonably available to it to suggest that the sublease was available for purchase. And that is at Knight Frank's, I needn't go to it unless you want me to, appendix to the defence at 1.3. The third fundamental problem is for CNM is that it made it clear to the judge that the amendment, and it makes it clear in this court in its skeleton argument, that the amendment to paragraph 74 is based on Knight Frank's defence. The reference for that is supplemental bundle 2 at page 29, at internal page 99. But there's nothing in Knight Frank's defence that supports this plea. And that's made clearer when we look at CNM's justification for the amendment to 74 at 60.1 of its skeleton, which is where it is said that the amendment to 74 expanded on the existing allegation. Now, in the pleading. Now, my lord, it's worth turning to that. Expanded on the existing allegation at 84.2.
Sorry, where are you reading from?
I'm so sorry, 60.1 of the skeleton, CNM's skeleton argument, C22, page 279.
Thank you very much.
So there it is said, at paragraph 74, there's an allegation that withholding of information relating to the Heartland Agreement was intentional, with a view to suppressing buyer interest and thus facilitating the acquisition of the development site by TTIL Meadows. This amendment expanded on the existing allegation, RAPC 8042, that receivers had taken active steps to cause Knight Frank to withhold from the market information about the Heartland Agreement. And one goes then to what is then said to be the basis of 74.
Sorry, I've lost you.
I'm so sorry.
Which paragraph are you in?
We're at 60.1 of CNM's skeleton argument in this court.
Oh, I see. Yes, got that. Yeah.
Which says that the basis for 74 is the existing pleading. So we turn to the existing pleading, and the existing pleading in relation to the Heartland Agreement. So we turn to that existing pleading at 84.2, page 149 internally of the bundle.
Mm-hmm.
And that says, it's all about the Heartland Agreement, and it says, as pleaded in paragraphs 25.3, 25.12 and 25.14 of the Knight Frank defence, on various occasions between the 30th of October 2017 and the 14th of November 2017 inclusive, the third defendant took active steps to cause Knight Frank to withhold from the market now information about the Heartland Agreement. And so, my Lord, this fits with the proposition I'm putting to you that the fundamental basis of the willful misconduct case is in relation to the Heartland Agreement, because even the cross-reference, which is said to be the basis of it, is about the Heartland Agreement. Now, my Lords, the first problem you'll notice with this is the chronology doesn't work. It can't have been about the Heartland Agreement because the receivers in Knight Frank, certainly in the first date, and there's a second date which is the 10th, which you see at subparagraph B of November, it can't be about the Heartland Agreement because it's common ground that they didn't know anything about the Heartland Agreement until the 13th, the conversation with Mr. Gaze, and then the emails on the 14th. And so it is pleaded that those paragraphs of Knight Frank's defence deal with the receiver's instructions to Knight Frank. And, my Lords, it's worth going to those paragraphs at supplemental bundle 1, tab 3, because it's quite clear, my Lords, that none of them refer to the Heartland Agreement. So paragraph, I'm afraid it's one of these Byzantine numberings, paragraph 84 Roman 2a is based on paragraph 25.3 of the Knight Frank defence at supplemental bundle 1, tab 3, page 27. And it is obvious from that paragraph that it's about the surrender of the wizard Headleys and not about the Heartland Agreement. And Knight Frank's amended version, which CNM ignores, of paragraph 25.3, expressly makes that clear. In the red. Paragraph 84 Roman 2b is based on paragraph 25.12 of the Knight Frank defence. Now, if I can ask you just to read the pleaded version of that, it says, on or about the 10th of November, not to release the receivers instructed Knight Frank not to release to potential purchasers documents provided to the receivers by the claimant's former solicitors relating to the surrender of the cafe lease and the sublease. Now, my Lords, crucially, those words don't appear in that paragraph of Knight Frank's defence. They've been interpolated. And we know that the receivers can't have been referring to the Heartland Agreement on the 10th of November anyway, because they didn't find out about it until the 13th. Paragraph 84 Roman 2c of this paragraph is based on paragraph 2514 of Knight Frank's defence. Now, it refers back to A, which we know is about the wizard surrender. It's nothing to do with the Heartland Agreement. And in case there was any doubt about it, far from suggesting that Knight Frank implored the receivers to tell the market about the Heartland Agreement, Knight Frank plead in the appendix to their amended offence, I'll turn you to this, Supplemental Bundle 1, Tab 3, page 52. So, sorry, it's tab 4.
Which page?
Page 52, internal paragraph 1.4 of the appendix to Knight Frank's defence.
Mm-hmm.
Paragraph 85 is denied, and this is the crucial element though. Based on the communications from the claimant and Mr Samady, it would have been quite wrong of the receivers to invite potential purchasers to submit bids on the basis of vacant possession being available. Now, my lords, where does this take us? It is clear, both from the chronology and from Knight Frank's defence, that there is no basis for the pleas at 84 Roman 2. Therefore, there is no basis for the key paragraph of the willful misconduct amendment, which is paragraph 74, which we are told is based on that paragraph. Returning then, my lords, to the next willful misconduct amendment, paragraph 75. This says, this adds an allegation of willful misconduct to the existing case. The receivers opened or caused to be opened an online virtual data room for the purpose of marketing the development site. The data room included the O3 cafe lease, but did not include any information concerning the surrenderer of that lease to which the title had been closed. Now, my lords, we say that's irrelevant. What mattered is what was the current lease position. It's common ground that Heartland had taken over the surrendered lease by operation of law. So the question was, what's the position with the sublease?
Okay. I mean, I follow that, say, when you get to causation, the particular holdings may not matter. But, well, put it this way, suppose you had known that the cafe lease had been surrendered. Surely it would have been wrong not to put it in the data room.
My lords, in that case, one goes to the pleading on what actually happened there, which we haven't yet been to, and perhaps I could return to that in a moment. But yes, if you had in your hands a surrender, then it should go in the data room. Your Lordship mentions causation. There's a circularity back to causation on willful misconduct here. It's very difficult to say it would be willful misconduct not to include it, unless it was envisaged that not including it would have a material effect on the value of the property and was part of this overall scam. So it does come back that way, my submission.
And I follow that. I mean, I know in the end you'll deal with gross negligence as well.
Yes.
Because obviously that particular point sounds with willful misconduct, but doesn't sound with gross negligence.
I will come back to gross negligence, panel. Just dealing with the amendments on willful misconduct at the moment.
But could it not deter potential purchasers if they think there are two obstacles to deal with, namely the lease and the sublease? They might think, well, this is all just too complicated, I'm not going to pursue this further.
So, in other words, my lord, if there hasn't been a surrender, they've got a lease to look at, and then they've got a sublease.
Yes.
That potentially, so the case which would be pleaded would be that you've taken away one obstacle with the Heartland Agreement, but you have still got the obstacle of the original Wizard Inn's lease. Where that breaks down, my lord, in our submission, because if the case is that the thing that the purchaser needed to find out was the sublease position, then inevitably they would find out, as part of that inquiry, that the head lease had been surrendered. Mr Samady and Mr Ross had bought this, the thesis is, for the whole purpose of making it easy. So the fulcrum of it still remains the Heartland Agreement. The fulcrum of the case remains the Heartland Agreement. The purchasers would have thought that it was easier to acquire it and potentially would have paid a higher price, is the case, if they had known about the Heartland Agreement. That's the only case pleaded on higher price. It isn't pleaded they paid a higher price if they had anything about the Wizard Inn point. And therefore, once you take that as being the fulcrum of the case, the Wizard Inn's point really falls away in our submission. It's not pleaded that way in any event, but can I come back to that on 80.2, which deals with that in relation to gross negligence? So, my lords, the plea then at 75 is added that the failure to include the information in relation to the surrender of the lease and information concerning the cafe sublease in the data room was a willful omission by the receivers to suppress the buyer interest. Now, my lords, I'll return to the lease when I come back to gross negligence on 80.2 and the factual scenarios surrounding that as common ground. But dealing just with the Heartland Agreement allegation here, it is said that the receivers willfully misconducted themselves in failing to put information in the sublease in the data room, in a context, my lord, in which Mr Samady himself would not provide them with a copy of that lease, despite that sublease, despite request, because he says he felt marginalised by the receivers at Knight Frank. And the allegation in relation to going to market come what may cannot relate to the Heartland Agreement because the email on which this paragraph relies was sent on the 17th of October, almost a month before Mr Samady's emails to Knight Frank and the receivers of the 14th and 15th November. And the reference for that, my lords, is 24.18 of Knight Frank's defence, which Mr Lundy explained to the judge was the basis of this plea, and the reference for that is Supplemental Bundle 2, tab 29, internal page 100.
I mean, in theory, that could still apply to the head lease, couldn't it? I I mean,
It could chronologically apply to the head lease, my lord.
and in theory, I know you say this is nonsense. It could be that the receivers were set on suppressing information about the surrender of the head lease.
Well,
and in that context, said go to market, come what may.
I'll turn to that, my lord, now because it's a recurring theme. So I'll go to 80.2 of the pleading of the reamendment.
Just while we're still on 75,
Yes.
go to market, come what may,
Yes.
may be the gist of, but is not actually an accurate quote of what is pleaded in the Knight Frank defence 2418. Is that the right reference, or is there something else? What that says is, come what may, we shall launch tomorrow.
My lord, that's another point. Yes. Yeah. I mean, it is the reference.
I mean, that is what,
that is the reference.
They've just got the
Yes.
quote wrong.
Yes.
Yeah. Okay.
So, my lord, the allegation in relation to the original lease is at 80.2 of the particulars. And that is dealt with at paragraph 87 of the defence.
Of your defence.
Yes, my lords, and that we've already been taken to it. That's at C12. Internal page 181. Now, at the top there, it said, CNM, despite being asked to do so, did not inform the receivers or Knight Frank that the 2003 cafe lease had been surrendered, nor did it audit and or verify the contents of the data room. The facts and matters set out in the appendix are repeated. Now, the appendix, my lord, is at C13, core bundle, tab 13. And there, my lords, you see the history of communications with CNM about this. And in particular, 1.5, Mr Samady did not at any time inform the receivers the 2003 cafe lease had been surrendered. Instead, he sent an email on 29th August 2017 attaching what he described as the latest tenancy schedule. And, my lords, in the reply at paragraph 60, that's C14, paragraph 60, dealing with this appendix, the email correspondence is admitted, and in essence, it's not denied that there was a failure to provide the surrender. It said that it was wrong, in essence, for the receivers to have relied on CNM for information about the surrender. And then, in relation to auditing the data room would be where it would be. you've seen the plea in the appendix in relation to that. The email correspondence is admitted. And so no copy of the surrender was provided by CNM, and the data room was not audited by them in a context in which they're saying it was willful misconduct not to put the surrender in the data room, and not to audit in essence, the data room sufficiently such that that was included.
I mean, how do we reach a clear view about this in circumstances where they say it was wrong of the receivers to rely on CNM, information was in the public domain, citers signed the surrender, there was actual knowledge of the managing agent. The nuance in all this is very difficult to ascertain from reading a pleading, particularly multiple pleadings all interwoven in the way they are without any clarity of any kind, isn't it?
Well, my lord, insofar as a case of willful misconduct or wrongdoing, however one describes it, is based by CNM on other people's pleadings, then insofar as those pleadings contradict that case, then that case cannot stand up.
Well, they don't, I mean, you're not really saying they contradict it, they add a different light to it.
No, my lord, I am saying they contradict it in relation to the Heartland Agreement, and the new allegation at the
We're not
court.
talking about the Heartland Agreement at the moment, are we?
No, my lord, but I thought your lordship was making a general point. If it was
No,
any-
I'm making a specific point.
I'm sorry.
You said in paragraph, you drew our attention to paragraph 60 that admits email correspondence, right? But ignoring paragraph 59 as to the appendix, which says the context they rely on.
Yes, I understand that, and your lordship would say, well, aren't we in mini trial territory?
Yes.
Yes.
That's
Well,
what I'm saying.
Yes, I do understand that, my lord. And I will return when I come back to gross negligence to this vexed topic of the head lease. But if I may just finish the willful misconduct section, I'll then come back to that, because at the very least, my lord, even if your lordships would say, well, perhaps there is the vestige of a case here in relation to...
Well, even the judge said there was. The vestige of the case.
Well,
If that's
my lord,
the right test.
she wasn't dealing with the head lease. What I was about to say was, if there is a vestige of a case in relation to the head lease, there is no case in what has been set out in extenso in relation to willful misconduct on the Heartland Agreement, and what forms the core, as I'll show when I go to the paragraphs on breach, of the case on gross negligence as well. Now, the judge was only dealing with the willful misconduct case in relation to no real prospect of success because of what she had found in relation to gross negligence. And she was only dealing in that context with the Heartland Agreement, partly because there is at the core of the allegations of willful misconduct are the Heartland Agreement. You go to paragraph 74, that is based on the Heartland Agreement. Insofar as 75, Roman 1, is based on the head lease, then it is said that there was willful misconduct in failing to include the surrender of the head lease in the data room. Now, my lords, stepping back, that is mere assertion. There is no factual and evidential basis to support that once one strips out the allegations in relation to the Heartland Agreement. And, my lords, one has to remember that the whole process here was hand in hand with Knight Frank, against whom no allegation of misconduct or wrongdoing is being made.
But what I find difficult, Mr. Simpson, which you're going to have to address, is how you strip out facts in a highly factual and complex situation and say this fact is completely unsustainable when it's obviously part of a rather complicated course of action. And the thing that makes the allegation on your case unsustainable is not precisely that it's not true, it's that they reacted in another way to another request, which they may have reacted for 100 different reasons in that way. And we're being asked to say, let's strip this out and say it's nothing to do with anything, whereas we're actually looking at a rather complex factual situation, which, as we all know from years of experience in litigation, may look, you may be absolutely right, at trial this will look like absolutely nothing, but it may look completely different on the facts when we see witness statements and everything.
But also, of course I understand that.
And that's what the judge, it seems to me, was saying. She said, look, it looks a weak case, it looks speculative. And then she said it again and again, and not just in relation to Heartland.
Can I come back to, there's a further point here, of course, my lords. I've been focusing, as Mr Lundy did, on real prospects of success.
On what?
Real prospect of success or otherwise.
Yeah.
But the judge, and I will go back to that, but the judge was performing a multifactorial analysis.
Well, you can't have it both ways. In 3 places, at the beginning of her judgment, she says, this all turns on whether there's a real prospect of success.
Well,
And then you say she's performing a multifactorial exercise on permission to amend.
well, that's not quite what she says, my lord. She says that the strength or otherwise of the case is the main factor. But she considers various other factors. And in doing so, she was, when you face, my lord, just going back to basics, which you're of course aware of, when one faces an amendment application, late or very late, there are different factors in play. We're very late. Where you face a late amendment application, it's not simply a question of whether the claim has a real prospect of success. It is a necessary but not sufficient condition that it has a real prospect of success. There may be other countervailing considerations.
Yeah, but she didn't take any of those countervailing considerations. She ruled them out one by one.
In that case, my lord, perhaps I should turn to the
I think you should, yes.
judgment, which I'm trying to uphold. But
Yes. Well, somebody's got to. It's quite important what the judge says.
of course, my lord.
It starts at paragraph 2. It's not very long.
We have dealt in our skeleton with the multifactorial analysis, my lord. But you see at 3, as regard lateness, it was not in dispute, it was a late amendment, although not very late. That's only one factor, and I'm not inclined to put too much weight on that.
In one sense, it was late, but later in her judgment, she says that the case is 2 or 3 years away from conclusion, which might suggest the case is just going on too long, but it's not reached very far.
She's saying in our submission that it's late in the procedural history, rather than late in absolute terms being with a trial date fixed. And then, so she doesn't put too much weight on that. And then she says, on the other hand, it's right to bear in mind the claimant left it until the 11th hour to serve its draft amendment, having apparently taken no steps at all to consult counsel. And so she looks then at the procedural history, and the procedural history was canvassed in detail before her. But she says, to my mind, the most important considerations are the adequacy of the pleading and whether it offers a real prospect of success. Now, my lords, that is why I have been analysing the adequacy of the pleading, the new pleading, not the old pleading, save insofar as the new pleading is based on the old. Then she deals with a point which is not pursued in relation to no plea of intentional recklessness. And then she comes back, after dealing with that point, to the real prospect of success point, paragraph 23, and says, I mustn't conduct a mini trial at 25, says that she's entitled to look at internal incoherence and inconsistencies. That's what we've been dealing with, or what I've been dealing with this morning. And this is all about weakness, speculativeness, real prospect of success. And then...
I just stop you in case you passed over it. You said in answer to my question that she decided the case on the prospects of success, that she'd taken in a multifactorial other elements. Now, where has she said, apart from I place little weight on that, where has she said that she's taking into account other elements apart from...
Well, she comes on to that. She comes on to that.
Good.
So my premise isn't that she considered only real prospect of success. She considered it. She made various remarks about it. So on the next page, at the bottom of this page, 28. Ms. Barter relied on the fact the case was not pleaded from the outset, despite the involvement of senior experienced leading counsel at various stages. She discounts the fact that it wasn't on the pleadings from the outset, but then says the position is different post the Foxton judgment. Again, it might be said, well, that goes to the strength or otherwise of the case. She then...
Sorry, why does that go to it?
Well, as, for instance, Lady Justice Carr said in the Carr case, she was entitled to take into account the fact that a new plea had been put, which had not been put.
Well, I know, but I'm not talking about what Lady Justice Carr said. I'm talking about what Ms. Julia Dyer said. It does seem to me that the position after Foxton's judgment on preliminary issues is different. It's apparent that a QC was involved, but no attempt was made to raise willful misconduct. She said, I discount the fact that it wasn't on the willful misconduct, wasn't on the pleadings from the outset. So,
Yes, but what she's doing, my lord, she's drawing a distinction between that and after the Foxton judgment.
Okay.
Then she deals with the fact that no disclosure has taken place yet, and cannot be said for certain nothing would emerge. Considers the question of what evidence is before her. She's still here on prospects of success. And then says, so that's the background against which I ultimately have to consider the balance of prejudice. This is the multifactorial bit.
Having said that, even if it can't be said the case is bound to fail, it's weak and lacks conviction.
Yes. And so, poorly pleaded, inadequately particularised, not obviously promising. And then she takes into account we were in territory where the receivers could fairly claim to have been mucked about. Don't overstate it, she says. Taken too long. Nonetheless, it's a very serious allegation to make against professional people, which has been raised at the last minute in a claim that had been ongoing for 4 years and could and should have been raised months ago if it were going to be raised at all in the light of the history since the Foxton judgment. So we say that's part of the multifactorial analysis. She bears in mind the trial still in the dim and distant future, disclosure not taken place. She's carrying out a balancing act here. She's not just looking at real prospects of success. And then she turns to the overriding objective. And the courts need to manage cases so as to save expense and deal proportionately with them, allotting appropriate share of court resources. Then she takes a step back, balances all the factors in the scales, and says speculative and weak, charitably assume it's just about pleadable. In my judgment, in the context of the consideration she's given, wouldn't be right in or in accordance with the overriding objective to allow it to continue for another 2 to 3 years. And then she bears in mind another factor, that this was the claimant's last chance to put its house in order, and plenty of time following the preliminary issues hearing when it had the benefit of counsel and solicitors in order to formulate and put forward an amendment. Even after the consent order in unless terms, it was left at the 11th hour to approach counsel. And as I said above, if the claimant's now found itself in difficulties, they are, I regret, entirely of its own making. Now, we submit that is... Sorry, my Lord.
Go on. I'll probably come back to you in a moment.
We submit that this is a multifactorial analysis, and that she is not just taking into account whether there's a real prospect of success, and that in the context of amendment and of a procedural history of amendment, that real prospect of success is not the only thing you take into account. For instance, in the Qua case, before Lady Justice Carr, Goldman Sachs conceded that the amendment had a real prospect of success, and yet for numerous other reasons. I use that as one principle rather than as a argument by another.
I can't remember. Was that a very late amendment?
It was a late. It was a very late.
And then different criteria.
Understood, my lord. Yes, I accept that.
So just coming back in terms of being multifactorial, we can see that the judge took into account the fact that she thought the claim was speculative and weak.
Yes.
Can we just see what else she might have taken into account?
Yes, my lord. I mean, I'm just hunting for our skeleton where we actually set this out, but of course it's disappeared under numerous files. I'm sure Miss Barth will give me a copy of it. Page 309, my lord.
Which paragraph in your skeleton?
83.
I mean, it's all true. She said all those things. But I think my lord's point is, what was the main burden of her decision? And one can't help thinking, because she goes through all those things and says, well, they're not, that's not particularly important and that's not particularly important or any limited weight. What's the heavy weight? And the heavy weight, anyway, on a fair reading of it, seems to be, and you drew attention to what she'd said at the beginning as to what the really important point was, which was the merits, seems to be the merits, what she thought about the merits. And so one reading of this case is that she's done what commendably judges sometimes do, which is to say this case needs putting to death because it's weak and dreadful and probably won't succeed. But actually, it's not unarguable. And you're right. I mean, if it were very late or there was some other factor that made it unlikely, improbable, some different improbability. But she actually takes all the improbabilities into account and concludes it is arguable, just. And that's what I'm balking at.
Yes, I understand. It's clear what your lordship's balking at, but I think if one looks at it, what she says at the outset is undoubtedly that the most important factor is the prospect of success. As I said to my Lord Justice Males earlier, having set herself the task of deciding whether there was a real prospect of success, she uses language which is not necessarily consistent with the summary judgment threshold having been met.
No. Well, let's assume she thought what she says.
Yes.
Which is, this is a jolly weak case.
Yes.
It is probably, unfortunately, probably.
Yes.
She didn't say certainly, probably not going to succeed.
Yes.
where does that leave you if it could succeed? And this is the mini trial point.
Well,
You know, in Opackby, I was upbraided by Lord Hamblin for conducting a mini trial in the Court of Appeal, which, by the way, I would still contend I didn't.
hold on those ones.
But he said, court must not do that. If it's okay on the pleading, it's okay on the pleading.
Yes.
And this is why I was quite keen to look at the pleading,
Yes.
sort of from A to Z, but I've done that myself, so you don't
Well, I
need
got
to
to A.
take me through it.
I got to A.
I got to Z. But you
But-
see what I'm struggling with.
I do, my lord. So just one has to try to separate out the individual strands. So, question one: did the judge exercise her discretion wrongly? She took into account, however adequately or inadequately your lordship may think she did, various factors, including the strength or otherwise of the case, and she found it was weak and she assessed that it was weak and speculative. If your lordships were to find that that was so far out with the reasonable bounds of exercise discretion that it should be set aside, then we're into different territory of your lordships reconsidering the point.
Well, let's start from a different starting point.
Yes.
Let's assume that point one of what Mr. Lundy has argued is correct, that she shouldn't have found that you were in breach of, they needed relief from sanctions.
Yes.
And let's assume in his favour that she got off onto the wrong start by assuming they needed relief from sanctions to put in a claim of gross negligence.
Yes.
But what she ought to have been doing is looking at the whole claim in the round to see if the amendment of willful misconduct plus the amendment of gross negligence could be dealt with separately, ought to have been allowed. Now, I think your first point is that doesn't vitiate her discretion on the willful misconduct.
Yes.
That's your first point. And
Yes.
you say she hasn't done anything wrong on willful misconduct, she would have been doing the same exercise, right?
Yes, I say that, and I say that if the discretion is vitiated, then an analysis of the pleadings on willful misconduct simpliciter shows that it has no real prospect of success.
Yeah, and you say
She
then
didn't
by
go far
respondent's
enough. She
notice,
didn't go that far.
you say by respondent's notice she was wrong anyway because she should have said there was no prospect of success.
If she didn't go that
But
far.
assume you're wrong about that too. And so, well, no, because otherwise, if you're right, you're right. That's the end of
Yeah,
everything. So assume you're wrong about that. You say, even if I'm wrong about that, the exercise she conducted was the correct exercise on an application for to plead willful misconduct.
Yes.
And you, Mr. Lundy, can't get your screwdriver into her judgment because she didn't say it was hopeless, and putatively Mr. Simpson's going to fail on that in his respondent's notice, but everything else she did was what she should have done.
Yes.
And she took into account a number of weaker factors which together overcame the fact that there was a just arguable case.
Yes.
And you say that's the proper thing to do.
Yes, and I go back to Lord Justice Lewison on the upholding of.
I don't think you really need judges to help you with that. I mean, it's obviously the correct thing to do, to consider all the factors, and you get leave to amend if you know, we've got countless cases.
It's always worth praying judges in.
Yeah, I'm sure it is. But, so that's what you say. And you say, so your first point, which is a substantive point, obviously, is you don't actually overcome the discretion because she hasn't done the wrong exercise.
Yes, I do. Yes.
Can I just ask you a few things? First of all, as to the question of whether she thought there was no real prospect of success, if she had thought there was no real prospect of success, that was all she needed to say, wasn't it? She didn't need to look at anything else at all.
No, other than in the alternative, that if she were wrong on that, then we aggregate the factors.
And so when she says taking a step back and balancing the factors, that rather
Yes.
suggests
So
she's not saying...
Your lordship goes inferentially to the fact she couldn't have thought that, because otherwise she wouldn't have thought it necessary to balance the factors.
So-
I take that point, my lord, but it may be that she felt we're speculating as to what was in the judge's mind. It's always dangerous, but it's maybe that she felt she just didn't have to go that far and enter into that forensic analysis because the other factors, when combined with the weakness, meant that you got there anyway.
So could we just look at the other factors?
Yes.
35 is overriding objective need to allocate court's resources and so on. And that's also the second sentence for 36 in the same vein, isn't it? It's overriding objective, allocation of court resources.
Yes.
Now, supposing you have a claim that you think has a real prospect of success, it isn't a very late amendment. Can you really attach much weight to the fact that it's going to take the court time to deal with it?
Well, my Lord, in our submission, yes. When one, one comes back to a sort of circular argument. When one takes into, let's say the judge got to the point where she thought, well, this is really nearly not enough, and then it would only take a small increment further. So I wouldn't submit that is a major factor in a context of an amendment here, but it is a factor. She took it into account, and with other factors, it appears to have tipped the balance. If I'm wrong in my primary submission that she found there was no real prospect.
Can we just try beginning of 37? I also bear in mind that this was the claimant's last chance to put its house in order. Well, when she gets this far, she's concluded that they've come up with a pleadable case, and one that potentially has a real prospect of success. Does the fact that they have, at that late, at the last chance stage, achieved that, have any weight?
Well, my lords, the procedural history here is unusually bad.
Yes, but she's wrong, isn't she? Because she's actually thinking that she's had to rule you out on sanctions, but she didn't rule them out on sanctions when she didn't.
So she's wrong, my lord.
So she's taking into account a procedural history.
Yes.
I know she doesn't expressly say it. Always on the putative assumption that Mr. Lund is right about this, that she's had to knock them out on gross negligence because they have been required relief from sanctions she wasn't going to give them.
Yes.
So that puts a bearing on what she's saying about it being the claimant's last chance to put its house in order. In her analysis, it really was. This was the...
Well, my lord, she's not double counting.
No, not
because she's entitled to take into account the same procedural history which led her to refuse to allow the gross negligence pleading to proceed when considering the exercise of her discretion in relation to the separate willful misconduct allegation, and that's what she's doing.
But if it was their last chance and they took it by pleading a case which ex hypothesi had a real prospect of success, then where does the fact that it was their last chance come in as a factor saying that even though they've done it, they aren't going to be allowed to pursue it?
Well, my lord, one goes back to the worldwide point about, I won't mention cases or judges, but one goes back to the point about defendants being mucked about. I think what one might suggest that the context of this being the last chance, of it being very late, of the procedural history, is a relevant factor to weigh in the balance when one is considering whether a case which ex hypothesi has real prospect of success should succeed. It is not the case, my lords, in infinitely variable circumstances, that cases with a real prospect of success should always be allowed to succeed, to proceed. And this is a case where, even if she found that it did have a real prospect of success.
Well, often the reason why that is so is because the other party will be prejudiced by the lateness of the pleading.
Yes.
But that's, and generally that has been regarded as a very important factor, even if not these days the be-all and end-all for late amendments.
Yes.
But the judge doesn't consider that at all, does she? And you don't appear to make a case that you are prejudiced by the lateness of the amendment.
Other than the being mucked about point, no, we can't
Yes.
say that much. And Ms. Barter didn't say it.
Can I come back to you on the mucking about point? But just in terms of, I think, my Lord's point, end of 35,
Yes.
the judge seems to attach significance to the importance of enforcing compliance with court orders and rules. But on this hypothesis, the claimant did comply. So how could the importance of enforcing compliance with court orders and rules matter?
Just looking at the paragraph.
35,
Yes.
last line.
Well, I think, as I said, she is aggregating factors in relation to the being mucked about point, short
Well,
of prejudice. But ex hypothesi, they have obeyed the rules and the order because they've served it by the 14th of January. Is the point your lordship's making?
Yes.
Yes.
So I wonder whether your mucked about point is really 33.
At which she says it's important not to overstay.
Yes.
What is the mucking about? What is the mucking about? There was there was a preliminary issue which sensibly decided what it decided. You then delayed a bit in not producing an amendment. You were eventually told you had to do it by the 14th of January, and you produced an amendment but didn't include gross negligence, and it took you a few more months to get around to gross negligence. I mean, that's the period within which the mucking about occurs, isn't it?
Well, my lord, there was before the judge the point that CNM had previously been in breach of 7 court orders prior to.
In the earlier history. I see.
My lord, I'll have a paragraph reference to our skeleton in a moment. For the Sparta skeleton, able skeleton. And so there was a significant procedural history here prior to the preliminary issue. And I don't know if your lordships have seen, I need to take you to it. We supplied a chronology last week. Mr. Lundy has said that he doesn't take any issue with the dates, but hasn't double checked it. But I don't believe it's controversial as to the procedural history post, in particular, the Foxton order. So there is a significant procedural history. Supplemental bundle 1, page 262 is the point at which history of non-compliance is taken, paragraph 37. I needn't take you to it, but it gives the history.
Thank you.
My lords, wherever one is on the judge's exercise of discretion, as it's quite clear that in considering an amendment, one has to consider the terms of that amendment and the inherent likelihood or otherwise of that. And I've done that in relation to paragraph 74 in relation to wilful misconduct, paragraph 75, and also paragraph 80.4, which is said to form the basis for 74. My lords, whatever the position, if your lordships were against me on everything, then there are still paragraphs of this pleading which are crucial, which cannot, we say, survive. 80.42 cannot survive. The new 74 cannot survive. The new 75 cannot survive insofar as it's refers to the Heartland Agreement. And in essence, my lord, the whole that the whole case related to failure to bring the market's attention to the Heartland Agreement cannot survive. Now, my lords, your lordships might say, well, that's all very well, but if it's going to trial anyway, why don't we just leave it in there and you can deal with that if you want to. That is a very major element of the claim. It's absolutely at the heart of the claim. If one goes to paragraph 80, which is where the breaches are stated, then the Heartland Agreement is at the core of 80.3, 80.4.
There's no allegation to strike out bits of this, are there?
No, my lord, but insofar as it's said to form the basis for a wilful misconduct case, then we say the wilful misconduct case can't survive it. Because the wilful misconduct case, one understands this with litigant in person, my lord. What Mr Samady's done is he's added earlier paragraphs. He doesn't think, well, this should go in the brief section. He's added the early paragraphs, but he prays in aid the later paragraphs. And in particular, for 74, he prays in aid 84.2. Now, if I've already dealt with 74, I've already dealt with 75, but if one looks then at 76, these are very serious allegations against professional people. In principle, such allegations can be made, but if they are made, they need to be properly particularised. And one says in 76, well, what's the particularisation of the fraudulent or willfully misconducting the case here? It's a mere assertion, my lords. There's no case pleaded here separate from the earlier case on willful misconduct, which relates back to the Heartland Agreement. Once you strip out the Heartland Agreement, what is this? If a case has to be properly particularised, this adds absolutely nothing. It merely asserts it was a stitch-up of some kind. Likewise, if we look at 77, there's a new allegation there in relation to pre-Christmas exchange. Now, when Mr Lundy took you to the Knight Frank pleading on the bid process and on the conditions for the bids, it's notable that there's no clause or no allegation or no averment in the Knight Frank pleading that the completion had to be pre-Christmas, and there is no evidence for that at all. So, my lords, paragraph, just running through the steps in reasoning rather than taking your lordships in extenso to the pleadings. You've seen paragraph 53 of the defence, which sets out some of the bids. You've also seen paragraph 53 of Knight Frank's defence, which refers to bid schedules, and I've taken you earlier this afternoon through the bids. Now, paragraph 21 of CNM's amended reply says, pending disclosure, no admissions is made as to all this. And yet, it now pleads a positive case that the original bids required completion before Christmas. But on what evidential basis? Well, there is no evidential basis relied upon. And if it can only not admit these things in relation to the bid process, how can it make a positive averment that there should be a completion pre-Christmas? Likewise, it goes further than that. It's part of that broader case that Meadow uniquely was offered extended completion after Christmas, which was not offered to any other bidder as a support for the willful misconduct case. Now, paragraphs 54 to 59 of the receiver's defence deal with the second rounds of bids, and you've seen the pleas of the second round of bids. They're consistent with Knight Franken and receiver's pleadings. And at paragraphs 22 to 4 of its reply, CNM takes issue with one point on all that, but otherwise says it's not admitted. Now, on the basis of non-admission of the whole bid process, and on a basis that they don't know what happened and they have to rely on Knight Frank, on what basis is it said that it was a condition, a term of the original bids, that there should be completion pre-Christmas? If you can't admit anything that happened in the whole process, how can you say that it was offered to Meadow uniquely as some form of stitch-up? So not only, therefore, is the case inadequately particularised in relation to particular failings, the only actual particular failing that is given has no evidential basis in a context in which they themselves have said we don't know what happened during the bid process and we can't admit it. And also, this positive case is not consistent with the only positive case it has pleaded on this issue, which is at paragraph 20 of the reply, which Mr Lundy did take you to, which states that Mr Samady told the receivers the parties he met had informed him they had insufficient time to assess such a complex site as the development site, and that the time allowed for making first bids was inadequate, especially with the approaching Christmas period. And see also 22 of that reply, which fairly Mr Lundy took you to, which says that Trinity and AG complained to him of inadequate time being allowed in the bidding process. No complaint made about the completion date. So this allegation is plucked from the air, inconsistent with non-admissions, and not consistent with the case that Mr Samady, the CNM has pleaded in relation to what the purchasers told him. So, my lords, we say that none of the allegations in relation to Heartland Agreement and misconducting themselves in relation to the Heartland Agreement, which is really the core of the case on misconduct, willful misconduct, has a real prospect of success. That's 74, 75, barring the existing Roman 1. 76, totally unparticularised, mere assertion. 77, no evidential basis, inconsistent with non-admission. And I just repeat the points I made earlier. Turning then to the allegations of gross negligence. What happens here is, by the plea of gross negligence, the negligence pleas are converted into gross negligence. There's no additional fact pattern pleaded here, which would mean that there was gross negligence. So there are no new facts. So one says, are the existing facts pleaded sufficient to get home on a case of gross negligence? And we say, for the reasons given in our skeleton, that they are not. And in particular, we are entitled to observe, even if we haven't applied to strike out paragraph 84(2), that paragraph is inconsistent with the very paragraphs of the Knight Frank defence upon which the CNM is relying. And Lord, having gone slightly out of my planned course, perhaps I could just have a moment to consider.
Just before you do, can I ask you about paragraph 80.1?
Yes.
The marketing period was too short. Now, and that may derive some support if Mr Samady is right about what he says he was told by purchasers. In principle, that's a viable plea, isn't it? And we don't know, certainly I don't know, whether a period of 40 days for marketing a property like this is so short as to give rise to a reasonable inference that the receiver's hearts really weren't in it and they didn't want to sell it because they had this scheme up their sleeve, or whether, as no doubt your evidence would be, that it was a perfectly adequate period and proper estate agents were on the scene and all the rest of it. I mean, how do we resolve that?
My Lord, I accept that in principle 80.1 is an adequate plea of negligence. But if the more serious allegation of gross negligence is to be made, then in our submission, more than a mere assertion needs to be pleaded. Mr. Justice Foxton referred to an enhanced fact pattern in relation to gross negligence. And simply saying, well, we pleaded it was negligent, but now you've held it can only be gross negligence, it was grossly negligence, not enough. That's the simple answer to that. But in principle, yes, I accept that it is capable of being a non-demurrable allegation of negligence.
Well, you might say it could be negligence, but it doesn't look like gross negligence by itself.
I think I might be falling into a trap if I said that, because I'm not one the Lordship was setting, but I might be taken as saying, well, in that case, then it's all a matter of expert evidence if it's not is or isn't gross negligence. The point I'm making is a bit narrower, which is in a context in which you're suddenly upgrading your case from negligence to gross negligence, then you need some pleaded factual justification for that, or perhaps some expert evidence. Not vital, but
doesn't it slightly depend on what the expert says? I mean, we've all seen experts' reports that said this is really ridiculous. We would never have done this. We'd have given a 3-month period. We'd have been out marketing it, blah blah. Or they may say 40 days is perfectly reasonable. I mean, none of us know.
Well, my lords, I do understand that. I come back to the point. Of course, when one gets into a match between experts, then one's into a trial. But where one is pleading, upgrading a plea of negligence to gross negligence in the wider context of this case.
Can I ask you another question just before you sit down? Let's assume that we go with your submission that I slightly put to you, which is that actually there's nothing wrong with what she did on willful misconduct, right? And therefore willful misconduct goes. But obviously, again, on the premise I put to you, gross negligence, she did do something wrong. She didn't address her mind to it. What do we do? Do we address gross negligence without regard to what she decided on willful misconduct, and make our own balance of the various factors? Or are we to say, well, willful misconduct is gone because she did it right, and it doesn't matter whether we agree or disagree. But it makes no sense to leave gross negligence, so that should go too. What do we do?
Well, that latter reasoning I couldn't advance, my lord, simply because you've got rid of willful misconduct, you must get rid of gross negligence. Because she did not consider whether there was a real prospect of success on gross negligence, my submission, the only course for your lordships would be to consider that point afresh, because not even afresh.
Well, we would be considering that, but we'd actually be doing the balance of multifactorial balance that she did as well.
Yes, you would. So I should put it more clearly. You might first of all say, well, has it got a real prospect of success? And then you'd say to yourself, well, if it has, it scrapes over the bar, weighing up by parity of reasoning with what the judge did, which I say was correct in doing a multifactorial analysis, your lordships have to carry out a similar multifactorial analysis in relation to gross negligence.
I mean, it makes it slightly unsatisfactory, which is why I'm asking you, because the more satisfactory conclusion I mean, let's assume, and I don't know if this is the case or not, but let's assume that the judge reached the conclusion she reached, but we wouldn't have agreed with it, but we don't think it's a breach of her exercise of her discretion. And we exercise our discretion differently, leaving gross negligence in place, but if we'd been hearing the whole thing, we would have had them both in place. Now that all sounds a bit unsatisfactory to me, but you know, it's a little bit like I always complain in my younger days about judges who sort of reached an impeccable stream of reasoning, but very tortuous, and came to a conclusion and never asked themselves at the end, is this the right conclusion? And it looks like the wrong conclusion. It looks like a funny conclusion to me, let's say. What are we supposed to do? I mean, can we say, for example, could we say, in theory, well, she ought to have been asking all the right questions in the case, and she was only asking some of the right questions, so we ought to start again. Can we do that?
Well, my lords, this depends at the outset at whether your lordships find that she exceeded the ambit of her discretion on the misconduct.
So if she didn't, that's it, finished.
If she didn't finished.
Yeah.
Now, the difficulty your lordship is referring to, which my submission is more appears to be a difficulty, but isn't. Is well, normally in a case, you see numerous cases in which judges say, well, we wouldn't have done this, but this is a first instance court. And the issue troubling your lordship, I think, is, well, it's going to be particularly stark here if we weigh the same factors and we come to a different conclusion. But all that will do, my lord, is exemplify the fact that the Court of Appeal will stand by first instance judges in exercise of their discretion, even if we would have exercised it differently in the same case on another matter. Well, we're going to do that, even if it's inconsistent. And in my submission, that is simply consistent with the whole way the appellate jurisdiction works, and doesn't throw off that.
What about this scenario? Suppose the judge was wrong to knock out gross negligence on the relief against sanctions point. So when she came to consider the question of amendment, she should have been looking at both questions, and because gross negligence is a less demanding hurdle for the claimant than willful misconduct, there is the possibility that she would have allowed a gross negligence plea as having a real prospect of success. It wouldn't have involved, for example, the factor that she gave some weight to of serious allegations against professional men, or at any rate not to the same extent. And having allowed gross negligence in, she might well have thought, well, the case is going to trial, I'll allow willful misconduct in as well, because it tips over real prospect of success, and the other factors don't outweigh that. Now, she's deprived herself of the opportunity of considering that by the approach that she took on this hypothesis of knocking out gross negligence on a mistaken preliminary basis. What do we do then?
Well, my lords, these conundra are interesting. But in my submission, the primary question your lordships ask yourself is, was she out with her discretion in relation to willful misconduct? And your consideration of that will include a consideration of what a reasonable judge would have done, if the reasonable judge, if your lordships find this, if she had in fact allowed the gross negligence case to proceed. So it would form part of your lordships considering whether she had in fact exceeded the wide ambit of her discretion. That will be the stage of the argument which will come.
Can I try yet another scenario?
It's like a Viva.
We're on gross negligence for the purposes of this scenario. And do you say, well, suppose the judge was wrong about relief and sanction, we have to apply our minds to whether or not to grant permission for the gross negligence amendment, and you say at that stage we bring into account not merely whether there was a real prospect of success, but other factors as well. Can we suppose for a moment that on gross negligence there is a real prospect of success? you say we go further. Mr Lundy says, fine, forget about the plea of gross negligence. I'm just relying on what's in the pleading. I don't need amendment at all. Therefore, if there is a real prospect of success on this pleading, go no further. I'll tell you now that I'm alleging that this negligence was gross, but I don't need to amend. What happens then?
Well, the forensic difficulty there for Mr. Lundy in this hypothetical world would be that before Mr. Justice Foxton, it was common ground that gross negligence wasn't pleaded or alleged. And so it's quite difficult to find it's been hiding in plain sight, as Ms. Barton put it.
Well, except it's a legal plea, isn't it? You plead facts.
It's not a cause of action.
Well, it is in his order, actually, that establishing gross negligence is a high threshold, and no case to that effect has as yet been pleaded.
Yes.
But I mean, he could be, the order could be wrong.
It could be.
Because, as I say, I'm not sure, I haven't seen any argument about it, but I'm not sure that you actually need to plead what your cause, what you need to plead. I mean, I can see it's much neater to say gross negligence in the pleading, and you probably, perhaps, could say you actually need to, but equally it could be argued you don't.
My lord, one could debate exactly. I mean, the debate on gross negligence has gone on for years.
Yeah.
And various people have said various different things about it. But the single certainty is, in the context of this case, if you were going to plead, first of all, that it was common ground, it wasn't part of the case before with Justice Foxton. And that is a relevant part of this history. So if you're going to plead gross negligence, you need to add something to it. It comes down to that.
Okay.
One moment, my lord. One moment. No further submission.
Thank you very much, Mr. Simpson.
Some
Yes,
very brief points by way of reply. You may recall there was a passage in the pleadings which I didn't take you, and I couldn't find the right reference to it. It is at tab 4 of the supplementary bundle. It's in the receiver's reply to the Knight Frank defence. It's a document we haven't then looked at. And it was at it's actually page 57. It's paragraph 13.9. You may recall I was saying there was a passage which talked about referring matters to Mr Samady, and this was the passage which I had in mind. It's discussed, it relates to a meeting which occurs before the marketing is to take place. It's a meeting between it's an email. It's actually an email. And you see, accordingly, the receiver is determined to launch the campaign on the basis of any information subsequently provided by Mr Samady could be added to the data room as and when provided. Any request for further information from interested parties could be relayed to Mr Samady as and when received. And that, in my submission, that supports a general case that in a sense is what ought to have happened. That's what is being pleaded on behalf of CNM, and that's what didn't happen. And of course, it sort of then cries out for an explanation as to why it didn't. It's only fair on the learned deputy judge that I explained a little bit about how we got to where we did in the hearing before her, because much of this was not canvassed. The reality is, and I can take you to the relevant passages in the transcript, is I made some broad submissions. Now having looked back at it, I can see I did take her to various parts of the pleading and cross-reference them in various places. And I did make some fairly broad submissions which about the totality of our case, and perhaps the pithiest version of it is at page 409 of supplemental bundle number 2.
What's this directed to?
This is no, just by way. One of the questions which arose is this all new? What went on before the deputy judge? And so I thought I ought to draw your attention to it, because I think it was being said that in fact actually me putting the case on the basis of a number of different factors was not how I put it before the deputy judge. In fact, I did. My case had always been you take into account all the matters which I'm been referring to rather than just the Heartland Agreement. And I'll come to how the Heartland Agreement came up.
It wasn't his, wasn't Mr Simpson's submission that you had.
No. But just by way of clarity, you'll see broadly what I say.
I mean, you were replying to his submission, so. If he
No. Well, also it was a point which was made before lunch.
Okay.
409. You can just see it there. And just so you know, the whole point about the Heartland Agreement arose out of it. Most of the argument that day was directed at abuse of process. It arose only, the Heartland Agreement point arose only by reference to paragraph 63.5 of the respondent's skeleton argument. And we dealt with it in very short term. I'm just trying to find the reference for you to that. It was paragraph 63.4, page 275 of supplemental bundle number 1.
Yeah.
63.4. The point wasn't really dealt with by way of oral submission, from my recollection. I've been back to check the transcript. I remember it coming up in the course of my reply.
Mm-hmm.
And so, in fairness to the judge, there was very little by way of oral argument directed towards her. So I think I just need to make that entirely clear.
Right.
My lords, I don't think those are the only 2 points I thought I ought to draw attention to.
Anything else? No. Well, thank you both and your junior and solicitors, insofar as there are solicitors. We'll take time to consider our judgments. When you get them, please let us have typographical only corrections, and make sure you adhere to the embargo in the judgment, and agree, if you can, costs and the order, and use the judgment only for the purpose of doing so. And if there is any disagreement as to costs and the disposition of the case, then we will deal with all that in writing. Thank you very much.
All right.